civil rights attorney on behalf of the estate of Michael Dean, who was killed by a police officer on the side of the road here in Temple, Texas on December 2nd of 2019. This family has now waited for 2 months for the most surreptitious, the most, quiet investigation I've ever been a part of. I've never seen so little information released about a shooting prior to an indictment decision. The family, of course, is relieved that the city, that Henry Garza is going forward with criminal charges against this officer, but we are extremely disappointed in the charges that he's decided to move forward with. There's nothing about the facts that have been made available to his family or to the public that is consistent with a manslaughter charge. What manslaughter says in the Texas Penal Code is that there was no intent to cause serious bodily harm or death. Obviously, when you take a firearm and you shoot someone in the head, there's a serious intent to cause bodily harm or death. You can expect that bodily harm or death will result when you shoot someone in the head, and that is consistent with the charge of murder. And so we, as a family, as a community, we're calling on the Office of Henry Garza and the Bell County District Attorney's Office to up these charges to what are appropriate or consistent with the evidence, which will be murder. At this time, we'll take questions.
What's the next step for you guys at this point? What's the family said about these charges?
They said what I just said, which is it's obvious that there's no intent. Their concern, of course, is that maybe there's information that they know that we don't know. Of course, the video has not been made available to the public, hasn't been made privately to the family or to my office, and so they've clouded this case in a deep cloud of mystery about what actually happened. We have been able to piece things together. So we have spoke with witnesses who said seconds after the stop occurred, the shot occurred. We haven't seen the physical car that said there was a bullet that went through the window. I mean, the car was sealed. What that means to us, to the family, is that Michael Dean couldn't have represented a threat to anyone, knowing that he was unarmed within the car. He was shot through the window seconds after it was stopped. So using the power of deductive reasoning based on the evidence that we have been able to fight for over the last 2 months, we know that the appropriate charge in this is murder. If the Rangers or the District Attorney's Office has some additional information, or the video will be more revealing to the public or to this family privately, we encourage them to release it. We will be moving forward with our civil suit in subpoenaing the video, dash cam, body cam footage of this incident. But that's not a response to these charges. Criminal charges must go forward against these officers. A civil suit is an insufficient replacement for the appropriate murder charges in this case. The district attorney has every right and every responsibility to file the appropriate charges, even if it goes against the recommendations of the Rangers Office. We saw that recently in the case of Amber Geiger, who the Texas Rangers recommended manslaughter, but the Dallas County District Attorney's Office in that case said that was the inappropriate recommendation based on her intent when she pulled the trigger and shot both John in the heart. That was clearly an intent for murder to cause serious bodily harm or death. If that was consistent in that case with one shot to the heart, then certainly one shot to the head is consistent with murder. The Bell County District Attorney's Office has a responsibility and has everything at their discretion to ignore the recommendation by the Texas Rangers and to move forward with the appropriate charges. And if they do not, then we will be calling on the Department of Justice to come and look at this case. It is not okay to kill black men on the side of the road and charge officers with a bare minimum. A charge of manslaughter in this jurisdiction can carry a penalty as low as probation. Michael Dean will never be returned to his family. He will never come home to his kids. And so the idea that that the officer who killed him, Dick Cruz, could get something as low as probation is absurd and is unacceptable to this family.
So Lee, today we have gotten more details about that. So I don't know if you've been aware of what happened, but in the affidavit, it talks about that body cam. It talks about the Cruz walked up to the car, blocked Michael's car, tried to pull the keys out of the car. Is that something, like you were saying, that manslaughter charges shouldn't?
Yeah, again, police officers are justified. The only defense in here is justification. So police officers are justified to use deadly force if deadly force is being used against them or other members of the public. Nothing in the statements that have been released or the video that has not been produced yet is consistent with Michael Dean exerting deadly force against an officer or against members of the public. So absent that justification, the appropriate charge in this case is murder.
So the affidavit also talks about how DeCruz had his gun drawn as he approached the car. Do you think that's another reason why that should be a murder charge?
Well, when you get out of your car for a relatively minor traffic stop, didn't justify it. Now, we've heard a lot of phrases thrown out during the course of this investigation, like evasion, right? Evasion is not the justification for the use of a deadly force, particularly when a motorist voluntarily pulls to a well-lit, crowded area and stops his car. That's not evasion at all. That's being a responsible driver in a climate where black men are killed on the side of the road by law enforcement officers all of the time. And then we heard an altercation took place on the side of the road. The definition of altercation being a loud argument. Again, that's not a justification for deadly force. And so certainly, without the proper justification, in which no one in these affidavits, the video that they failed to produce, or anywhere in this investigation has produced any form of justification, then again we double down on our call for the appropriate charge of murder.
So when you talk about videos, we obtained video from him circling the area. We've also requested the gas can video, but we're told they cannot release it because of witnesses. They don't want to tamper with the case. Is that, what your experience is, something that is a justifiable answer?
No, it's not a justifiable answer. If they went completely quiet, which they tried to do for most of this case, if they weren't leaking out information about evasions, if they weren't leaking out information about altercations, and they wanted the potential witnesses that they haven't discovered over this time to be pure, then they wouldn't be releasing those statements ahead of obtaining affidavits from those witnesses. To my knowledge, my office is the only one who has obtained affidavits from witnesses. Again, I have not been made privy to their investigative file. But if they have done a thorough investigation, they already have the affidavits. And if they don't have the affidavits, it's a bit late. It's 2 months later. Memories become obscure at that point. So releasing the video, if nothing else, it does more for us to identify the witnesses who may have been possibly present in order to get their statements if they haven't gotten those statements yet.
And can you speak to the timing of it? It's 10 weeks today. With the cases you've covered in the past, has it been this long to get just this much information so far?
No, this is the most obscure, the most secret, the most illegitimate investigation I've ever been a part of in my career. And I work cases all over the country. I knew from the onset that this case would result in an indictment because if there was any justification, we know that we would have received that a week, 2 weeks, 3 weeks tops after this incident. 10 weeks later, we knew that there was no justification they could come up with. The best they could do was stall out and hope that media interest wanes, people stop paying attention, and that they can get away with a charge as low as manslaughter, which this family and this community will not accept.
How are the charges brought to your attention today? Has the district attorney been keeping you guys in the loop as the family? Were they told prior before the release happened to all the media?
The district attorney's office refused to meet with me or the family prior to releasing these charges. I'm sorry, together with the family prior to releasing these charges. He was willing to meet with the family, but not willing to meet with my office. My family, of course, was unwilling to meet with his office without my presence.
Have you spoken to him today about the upgraded charges?
Only to that extent. And the invitation directly to the family to meet with him, which we declined. And since the charges were released, he has now agreed tentatively to meet with his family. My office is setting that up now.
So they found out through a release today is how they found out about the charges against Officer DeCruz?
They have found out through media sources.
Okay.
And we still haven't had a chance to see the file. You all probably know more about their file than we do at this point. They found out through me.
When do you think a civil suit might be filed?
We want to see the criminal case proceed forward. If we were to file a civil suit today, which we are prepared to file today, it would be stalled pending the outcome of the criminal investigation. We're in no rush to put words on a piece of paper that are just going to be stalled. We want to know what happened. And so when we will file a lawsuit when it's clear what happened. Okay. Thank you.
Thank you.